Lawyers. Has there ever been a time the opposing counsel accidentally proved your case for you and what happened? My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VOA and the property is HUD subsidized. Also MD law offers DV protections too. Landlord's counsel during his opening talked about how my client was beaten and the police were called and an ambulance etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response: no, your honor. I believe opposing counsel has said everything that needs to be said. Judge smiled and ruled in my client's favor. Landlord can't evict DV victim. I worked as an intern for a lawyer. Construction law in France are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360-degree picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. WTF. Anything that can be seen from the church bell's tower can never be renewed. That city will slowly disappear as buildings collapse in time. Not a lawyer, but I'm a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer, since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash or for fun has no bearing on the fact that he's doing roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work." The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. I had to go to court over a financial cock-up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor. So I went in alone. The judge didn't like this and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said, "I didn't tell you this but," and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right. Went to the second hearing alone and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about £9,000. Nice chapter. What a great act. That lawyer solicitor had every right to argue their case and try to win, but instead made sure a kid didn't get screwed. A+ person. Couldn't he had equally been disbarred? I love the gesture. But if it didn't turn out in some other young adult's favor. Easy to imagine them ranting in open court. Just the prosecutor guy showed me this thing and said it would let me win. Apostrophe. Not a lawyer, but took my Bill's landlord to small claims court. He's on SSI and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay. He did, and that's why she kicked him out. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming that the apartment was trashed. There were holes in the walls and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my Bill's apartment obviously still being lived in. His stuff was all still there and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can't see it. It's behind all of the posters." The judge frowned and looked at the video again and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. This should be a lot higher up. I'm glad your brother is safe now. I forgot to add that she also filed a TRO against him that we had to fight first. That old bat was a real piece of work. It was very satisfying when her son had to bring us a cashier's check for the judgment amount. Or we could, lawfully, put a lien on her property. We just have the bill living with us now. Not the most preferred solution, but the easiest to facilitate on a day-by-day basis. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console. In a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says this case is a circumstantial evidence case. During my closing, I slap the jury instruction on the projector that says if a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. A friend of mine was involved in a similarly bullshit case. He had picked up his mother's car to take it for some service. Got stopped for rolling through a stop sign. Police officer spotted a handgun poking out from under the driver's seat. It was his mother's gun, legal and registered to her. My friend didn't know it was there. Cop arrested him for possession of the gun. Don't know the specific charge. After months of BS from the prosecutor, it was finally dropped. Bet they never got the gun back without a mile of red tape and bullshit. 2. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel. Basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our complaint where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client? The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks opposing counsel. I guess you were ineffective for both of you. Just this past January my old boss asked me to prepare an opposition for a motion to dismiss. He had been working on a case a few years back and never properly filed his complaint. So the opposing counsel makes the motion based on the SOL. My boss instructs me to argue that the reason he took so long to proceed with the suit was because he was very busy with other clients. I had to politely remind him that he was basically reporting himself for a professional responsibility violation. Yeah, you really can't use that excuse. It's astonishing how often the rules of professional conduct get forgotten. Arnold. But the opposing party made it easy for us. We were tubing down a small river in rural Ohio. We had only been in the river for a quarter mile when we get stopped by rangers doing checks on who knows what. Probably 4 people drinking. They stop us, and after 30 minutes, tell us that we have to leave the river and give us a ticket. When my dad asks why, they say it is because the boat that my 4-year-old brother is using is not licensed by the state, and that it does not have the mandatory safety equipment on board, being life jackets, medkit, and fire extinguisher. I'm on mobile, so I can't post a link. But the boat is something you get from a Toys R Us for your pool. Long story short, my dad fights the ticket and, per their request, brings the boat to the courtroom. He said he walked in with the boat folded and tucked up under his arm. The judge asked, "Is this the boat in question?" My dad said, "Yes, Your Honor. If you give me 5 minutes, I could blow it up for you." He also went on to say that if the safety equipment was in the boat, that it would sink. He won right then. The court costs were as much as just paying the ticket. But it's the little things. The court costs were as much as just paying the ticket. But it's the little things. This is the part that infuriates me. If he was proved innocent, the Rangers were proved wrong, and the court ruled in his favor. Why the bloody F did he have to pay court costs? It's as if being accused of a crime is enough to be punished for. I was an attorney for the estate of a husband defending against claims for money by the separate estate of a wife over proceeds from the sale of a business back in 1996. Both husband and wife died in 2010. Suit was filed early 2011. Went to trial in 2014. Wife got around 10% of the business in 1996. Husband got the rest. He had built and operated it for 35 years prior to marriage and sold it 7 years into the marriage. The whole case hinged on whether the valuation of the business in 1996 was reasonable or not. We say you can't value a business 15 years later with all the documents gone and all the main people in the business dead or missing. They say they have enough info to show the 1996 valuation should have been higher. Opposing counsels gets a big time expert to testify that the business sold of $45 million based on a valuation, but should have sold for $70 million and the husband hid $25 million in real estate in the transaction. We get that testimony and then realize the 1996 valuation of the business was done by the same expert. This is the absolutely most perfect catch-22 I have ever seen. So now we ask, okay, so was your valuation wrong in 1996, or is it wrong now? Expert says his 1996 valuation was right based on the information he had in 1996, but his valuation now is more correct, which then bears the question, what information do you have now that you didn't have in 1996? Answer, I don't know. I don't have my file from 1996. Nobody keeps documents that long. And despite this lack of records, his valuation is somehow more correct now. Judge basically said the expert was talking out of both sides of his ear and we won. When I first started practicing, I handled a custody case where my client, mom, had a problem with dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied that he doesn't smoke tobacco, only weed in the house. Obviously this raised eyebrows as it is illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. He actually said this and doesn't recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. My public defender wife, not a redditor or I'd get her to speak for herself, was trying a case where the defendant was accused of filling fraudulent prescriptions. Now keep in mind, PDs deal with a lot of shady characters who maintain their innocence with increasingly implausible stories as the evidence gets worse, so you can get a bit jaded after a while. But you don't have to believe your client's story to represent them vigorously. So the prosecution has grainy surveillance video of someone who looks like the defendant getting the prescription filled and the ID used to fill it, which belongs to the defendant. Defendant maintains that someone stole his ID and is using it because they look similar, but never reported the ID as stolen. Wife is skeptical that the jury will go for that, but she's always willing to go to trial if that's what the client wants. So preps that defendant heads into trial. Prosecutor brings in the pharmacist who reported the prescription issue, goes through the usual routine of establishing who she is, where she works, was this the ID used that day, etc. Finally, the prosecutor asks the pharmacist if the person who attempted to fill the prescription that day is in the courtroom. No. Oops. Did the judge immediately dismiss the case? Jury was sent out, and after some conference with the witness the prosecutor dismissed it. Prosecutors get used to having it easy, so he didn't really do as much due diligence as he should have. Entertaining after the fact though. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. I'm getting mixed feelings about this one. It feels like a D move, but would probably make perfect logical sense. Care to help me out here? Question mark? I think what he was saying is that in order to admit records as evidence, you need a witness backing them who has in-depth experience creating and maintaining the records. For example, you would need an employee of a company who works in the payroll department to witness the payroll records from said company. Yup, if they'd brought anyone from human resources, they would have got the evidence in, and ordinarily you wouldn't question the admissibility of business records. But the opposing counsel comments triggered me. I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature. Since that's a serious accusation, I held up the guy's prior conviction for contract fraud and said I absolutely am. Your Honor, we won. Hands down. No further argument needed. Wow. Those guys were either incredibly stupid or stupidly confident in their skills of trickery. A mix of both, I'd imagine. My dad is a lawyer. It's happened several times that the defendant submits or provides video evidence of assault or unlawful detainment, but assumes it will go unnoticed in 50+ hours of footage. My dad watches everything. He got a multi-million-dollar settlement from a major casino after pointing out a moment that proved video doctoring. Edit, there was a car one too. He had a bunch of recordings and found a spot in the recording submitted by the other side where they are discussing what they need to show and how they will prove it. He played the recording in court as a surprise. They had nothing to say and he won after like 4 days of back and forth. I believe you have to get to a point where that evidence would come up. That's why he couldn't start there. My dad is a total badass. Why would anyone think that a lawyer wouldn't watch or have a para or office staff watch 50 plus hours of video you gave them during discovery in order to find what they need? That's what is known as billable time, and lawyers live and die on their billable time. It may not even entirely be that they assume he won't watch it, but it's generally true that they haven't watched it. These aren't hourly billing situations. But that doesn't matter. I always think it's so cool when my dad wins. Oh, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence, hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished the stuff like a bat before court. My parents' lawyer thought he had a good case until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client, "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Arnold was in court for a friend. The guy in front of us was contesting a ticket. His defense was that he was passing a car at the time, and they got the radar reading from the car he was passing, not from him. He didn't win that appeal. Plaintiff was claiming insurance money because he accidentally chopped off his fingers while cutting bamboo with a machete, and the insurance company, our client, refused to pay the insured amount. During the hearing, the plaintiff attorney began to demonstrate with a rolled up sheet of paper how his client was cutting the bamboo when the accident happened. No matter how he tried, he could not reproduce the position of the fingers with the alleged cut of the machete. The only possible match would be if the plaintiff had deliberately extended his fingers over a plane surface and hacked his own fingers. Based on this disastrous performance, the judge determined an expert opinion and later dismissed the case due to deliberate self-mutilation. While he was a jerk, one has to wonder what sort of trouble he was in to chop off his own fingers for insurance money. Not an attorney, but I did an internship at the city's attorney's office one summer, leading to not wanting to be an attorney. Man was suing the city for evicting him from a public housing development. Claims he doesn't speak English and forced the city to hire an interpreter for the hearing. City says he was evicted because he was raising chickens in the apartment. His attorney insists that's absurd. No one would do that. Pushes for proof that chickens were his clients. Judge wasn't convinced about the proof. Everything looks like it is going well for the guy until it comes up that the chickens were given to a farm for slaughter. Guy jumps up and starts yelling, "Give me my chickens back," in English. Judge starts laughing. Attorneys start laughing. Case is dismissed. It's quite a sadistic picture. Poor guy's devastated after learning that his chicken children have been sent to slaughter. Judge laughs. Attorneys laugh. Man now evicted. Scene. Not a lawyer, but was taken to court once. A guy had taken my family to court, basically he had been dating my mother, and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, "While I was with them, I bought all this stuff. I took them to dinner all the time and all this." But it was the idea it would be paid back by them. Judge, you bought a child a birthday cake with the idea it would be paid back. Did you ever say that these things were loans and not gifts? Well, no. But I shouldn't need to. That's the normal way people think, Judge. Well, that's not the way I'd think. Case dismissed. Well, Jimmy, happy birthday. Here is that BMX bike you wanted. Just remember that when you turn 18, you're gonna owe me $300 with compounded interest on a monthly basis. Welcome to the real world, jackass. Happy birthday to the ground. I threw the rest of the cake too.